Okay, and now we are ready to start. And as you will remember, we are in the middle of a lecture series on the Supreme Court and constitutional law. And we are, I think, prepared now to really get into the heart of the historical material, going back to the founding and the ratification of the Constitution and understandings of the way in which the Constitution and judicial review were understood in the late 18th and early 19th century. Uh, the jumping off point, the impetus for these lectures is obviously the change that has occurred on the Supreme Court over the last 20 plus years, and then the likelihood that there will be substantial changes in constitutional law or constitutional interpretation, the rights we have, the ways in which the court shapes our policy debates. All of that is, I think, coming down the pike. And so I want to focus on that. Give me 1 second. Karen, I think for some reason you're able to scribble on the screen. Are you seeing that? Am I the only one seeing it? Little green lines? Okay. Well, if, as long as it's not.
Yeah.
Pardon?
Yeah.
Yeah, I think that's Karen Nelson. So maybe there's something you need to change on your Zoom settings, Karen. But today I will continue with the theme of the historical origins and evolution of American constitutionalism and judicial review. Before I do that, I do want to spend a moment noticing that there are other things happening in the news that we are paying attention to as well. Of course, we had our first hearings from the special committee investigating the January 6th invasion of the Capitol a couple nights ago now. And I think one of the things to notice immediately is that 20 million people appear to have tuned in to those hearings, and that makes it more popular than the World Series, for instance. It seems that it has focused our attention. I think one of the questions will be, does it in any way influence American public opinion? And in particular, I thought the line that many people have focused on from Liz Cheney indicating to her fellow Republican Party leaders that Trump would eventually be gone, their dishonor would not, was a key moment in at least attempting to continue to appeal to the conscience of the leadership of the Republican Party. I think one of the things that became clear in the hearing is that there were a fair number of members of the Republican Party administration, Donald Trump's administration, who did not believe that the election had been stolen, who tried to correct the president, who put their fidelity to the American Constitution and the democratic project that it serves to organize above their loyalty to the individual man, the current president, right? And in a sense, if I've got it right, what Cheney is trying to do is, in a sense, call her colleagues to their senses, appeal to their sense of justice, in particular, their commitment not only to winning elections, but also to democracy. And I just wonder whether there's any chance that that appeal is heard and that it resonates with anyone in the Trump wing, the MAGA wing of the Republican Party, which is the currently dominant wing of that party, and alternatively, whether that appeal also reaches through the Fox News filter to some of the people who currently might be, in a sense, balancing which of the two political parties do they find most repellent. I think that there's a substantial portion of the American population that doesn't like any of the options presented to them and tends to approach politics as a choice of the lesser of two evils. Does this hearing remind people as their discontent with Biden and contemporary American circumstances simmers, uh, how much they were also unhappy with the alternative, and perhaps tilt the balance in that way a little bit. So just some brief reflections there. We will return to some of these themes. I will point out to you the other thing that I think was stunning about the hearing, and in particular, the documentary film evidence that it provided of the extent of the violence and chaos at the Capitol on, of course, probably the most important day in the constitutional calendar, the day in which the Electoral College votes are registered, that our democracy is increasingly fragile. The rule of law, our willingness to abide by procedures, and in a sense to allow votes and ordinary procedures to determine the outcome of our disputes is frayed, it is diminished. And so our democracy is increasingly fragile. And that seems to me to be very important as we consider how much we need to rely on the legitimacy, the authority, the respect for the federal judiciary, and especially the Supreme Court, as we navigate a very difficult, a very contentious, a very fractious period in American history. Second thing elsewhere in the news, the ongoing war in Ukraine. Our attention seems to have strayed from this conflict, at least if you look at the national news media, if you look at people's online viewership habits, people paying attention to the Ukraine, that has gone down 20-fold from the period in March when it grabbed everyone's attention. There seems to be a certain desensitization or fatigue setting in, but that does not mean that the war is not raging. And what we are seeing is that it is increasingly a war being fought for control of territory, meter by meter, kilometer by kilometer, right? It's not a war that is going to move quickly. It's going to be a war of attrition. It's increasingly an artillery battle, and the Russians have a clear advantage right now because they literally are able to fire 10 times the amount of munitions that the Ukrainians are able to fire. The Ukrainians' stocks of munitions, of armaments are depleted. They cannot return the Russian artillery fire in anything like a proportionate way. And one of the analysts who I was listening to the other day said something that I think is worth bearing in mind, which is, on the one hand, Putin has committed to the idea that the Ukraine is not a genuine nation, that it should be part of greater or mother Russia. And that, second of all, it is clearly the case that as the war drags on, the larger, the better equipped, and frankly, the military that obeys none of the constraints of humane warfare or the rules of war has the advantage, right? And so the analyst suggested, look, right now the Russians are trying to break the Donbass off from the Ukraine. It appears that that will likely succeed. Don't think that that means that the Russians will stop, right? This is a costly war for them, but it is at this point actually tipped in their favor. And so why not think that they will take the Donbass, regroup, and next go after Kharkiv? Take Kharkiv 4 bloody months later, and next go after Kyiv, right? And so although we seem to be distracted from this, that doesn't mean that there aren't urgent humanitarian problems being generated by the ongoing assault on the Ukraine. Having said that, those problems are now rippling out to the rest of the world. We are suffering, many places in the world are suffering from a dramatic food shortage that comes precisely out of this conflict. And the fact that the Ukraine is the breadbasket, especially for wheat and relatively wheat cheap, cheap wheat for much of the rest of the world, and especially poorer countries in the world. And we see the Russians blocking the ports and destroying the grain silos and warehouses, and so that's one aspect of this. And then of course the third thing I'm going to point to is inflation. We got the numbers yesterday, which were much higher than many economists expected. It makes it appear that inflation is accelerating, that it's likely to be long term, that it is broad based. Yes, the Russian invasion of the Ukraine and the embargo of many countries of the world of Russian oil have contributed to the inflation. But it appears that it is rooted in many structural factors in our economy, that the Fed is going to have to increase its efforts to tighten the money supply, which is the blunt and not particularly effective instrument that we have with macroeconomic policy to fight inflation, that there's an increasing likelihood that this will then dampen the economy in the United States, that there's a likelihood of recession here and perhaps globally as well. And so, like I said, that's just giving you a quick little window into some of the other stuff happening in the news that we will talk about in later classes. But today I want to continue with the overall course. We thoroughly covered the forces that have remade our judiciary, and the reason we should therefore expect that there will be a major rupture in the way in which constitutional law is interpreted, emanating from the current conservative originalist majority on the Supreme Court. I'll refresh your memories on that very quickly. And then we need to talk about both the origins and the evolution of the American Constitution and judicial review today in order to be ready to talk about the prospects for reform in the 21st century. And what I hope I will be able to establish is the idea that reform is, in fact, in many respects, continuous with the way in which the Constitution was understood at its inception, at least that we would not be doing violence to the Constitution by interpreting it and demanding that it play a more democratic role in our society. Let's hold off on that, but that's where we're going. I have noted that there are multiple important issues in front of the court right now. We should expect to see decisions coming out in the next weeks. There was an important decision last week about accountability for federal immigration customs enforcement officials that seems to radically diminish their accountability for their action against American citizens. Obviously, we're awaiting the abortion decision, which has been leaked, and we'll have to see if the actual decision is similar to the draft decision from February. There are major guns cases in front of the Supreme Court, major cases to do with the separation of church and state and the nature of religious liberty, major cases to do with refugee status and whether or not people who have applied to be refugees will be able again to enter the United States while there are hearings to determine whether they qualify under refugee status. There are major decisions coming down about environment, climate change, and more generally, the delegation doctrine and the ability of the federal government to continue to regulate in the way in which it currently regulates, in which regulations are mainly developed by executive branch administrative agencies. And then, of course, the other item in the news we're all, I assume, paying some attention to is that there have been multiple primary elections, including, of course, the recall election proposition for the prosecutor in San Francisco. But most of these elections have been primary elections, and that the court has really deeply influenced the way in which elections are conducted in the United States today, whether that is opening the floodgates for money in our elections or overturning significant elements of the Voting Rights Act, or continuing to permit partisan gerrymandering of a rather extreme and sophisticated kind. In many ways, right, the very structure of the electoral process by which we populate the political branches, Congress and the presidency, are deeply influenced by the Supreme Court. And so all of this to say this is a very powerful institution that has a peculiar democratic pedigree, and this is then going to really come to the fore, it seems to me, over the coming decade, since the federal judiciary has been remade, a very expensive, very sophisticated, very patient campaign, not just to populate the federal judiciary with more conservative judges, but to generate an infrastructure of intellectual conservative jurisprudence, history, and thought. I think in many respects, much of the creativity, much of the energy, much of the original legal scholarship in the American Legal Academy over the last, say, 25 years has been on the conservative side, on the originalist side of the debate about the Constitution. That this hasn't just been an academic campaign, but in fact has transformed the Supreme Court, which now has a 6-3 conservative majority, and the federal judiciary, which is probably, I think, about 2/3 Republican appointees at this point, reflects not only this expensive, sustained, patient campaign, but also the way in which the other institutions of the federal government that determine the composition of the judiciary amplify the power of a conservative minority within the overall American electorate. That the result is that we have an originalist majority, a majority who says that the right way to interpret the Constitution is to understand what it meant to the people who framed it and ratified it in the 1780s and 1790s, and that this is obviously opposed to the idea of a living constitution which evolves with each successive generation, and in which judicial interpretation is a key mechanism for the evolution of the Constitution. And even though there have been originalist justices on the Supreme Court for much of the last 40 years, I think the current originalist majority shows less respect for the principle of stare decisis, the idea that we are bound by precedents even when we don't necessarily agree with them, because the Supreme Court, the Constitution, the laws, the decisions that are made by that court form the fabric, the structure, the solid ground of the rule of law on which so many people rely in planning their lives. And so one should not willy-nilly overturn past decisions, even if one thinks they were wrongly decided, if one's on the Supreme Court in the position to do so, because there's a countervailing consideration, which is the stability of the law. And that past originalists, and especially when Chief Justice John Roberts seemed to be the fulcrum of the court, balanced the idea of overturning past decisions because they emanated from a judicial philosophy which these justices reject, the idea of a living constitution, or that the justices get to interpret the Constitution in light of current standards, as opposed to the originalist idea. They were tempered in their willingness to overturn past decisions by their respect for the need for a stable body of constitutional law. The current Supreme Court seems to be less tempered, less restrained in this regard. And so that is why I suspect we are in the early stages of a constitutional earthquake that is going to fundamentally overturn, upend a large body of constitutional law that has been taken for granted in the United States for, let's say, the last 70 years. And the next idea here, and I'm going to spend a minute on this, which is an idea that's simple in principle and very complicated in application, which is that we ask the court in its role as the interpreter of the Constitution to play two roles simultaneously that are somewhat tensely related to each other. On the one hand, we ask the court to overturn legislation that is clearly incompatible with the Constitution. And the idea behind that seems to acknowledge that the people are not always going to be, or the representatives of the people are not always going to be, the best advocates for maintaining fidelity to the Constitution. That sometimes, and here I will use Madisonian language, transient majorities will be motivated by fear or panic or enthusiasm or interest to do things that contradict their own constitutional commitments and principles, and that in that moment we ask the court to, in a sense, return us to our senses, to prevent us from doing things that violate our deep held constitutional principles and that presumably we would later regret, right? And so I'll give a clear, I think, example here. It's not one that the court actually intervened in, but in the aftermath of the terrorist attacks of September 11th, 2001, Congress did a number of things that I think many of us now regard as problematic. I'm not going to focus on the open-ended authorization for the use of military force, though I think that's an important issue. I'm going to focus instead on the Patriot Act and the way in which it was used to authorize broad-based surveillance on practically all Americans' cell phone communications and emails, at least the metadata associated with our electronic communication. And I think in retrospect, and Congress has revised this legislation, I think it's quite clear, many of us conclude that that was a mistake, that we have rights to privacy, that those rights to privacy are protected by the idea that the federal government needs a warrant in order to be able to surveil us, and that the warrant needs to show sufficient probable cause to be able to gather that information about us. And the broad-based nature of the information gathering in the aftermath of September 11th, authorized by the Patriot Act, and the way in which it was interpreted by the National Security Agency violates that. And I think this is one of those situations where if there had been a suit and that suit had made its way to the Supreme Court should have said, look, this legislation may have been supported by a majority. Almost everyone in the Senate voted for it, but it occurred as a result of a sense of panic. And we have committed to the Constitution from a place of quiet, stable conviction of principle in order precisely to prevent us from stampeding in panic over the rights of fellow citizens, right? And so the court at points is precisely asked to overrule the legislation that reflects perhaps the will of the majority, at least of the majority's representatives, because we acknowledge that at points we may get carried away. And on the other hand, right, there's the idea of a long held constitutional view of a stable majority of Americans. And let me give an example of this to illustrate this as well. During the early years of the New Deal, the first half of the 1930s, right? FDR had been elected president, solid majorities in both houses of Congress. FDR, responding to the Great Depression, began to pass a raft of legislation collected under the rubric of the New Deal. And the Supreme Court consistently invalidated large portions of that legislation, especially economic regulations, things to do with, for instance, a minimum wage. And right, FDR continued to win elections. The Democrats continued to win elections. They continued to pass this legislation. The legislation continued to be ruled unconstitutional and invalidated by the Supreme Court. By the time we get to the second half of the 1930s, right, FDR is talking about packing the court, about increasing the number of justices on the court in order to transform the court's majority to be less hostile to economic legislation. And the court doesn't get packed. The Democrats don't go along with FDR, but the court changes course. A couple justices resign, another justice changes his views, and now the New Deal legislation is able to get through. This is sometimes called the switch in time that saves nine. And I think to reconstruct this in the way in which someone like Bruce Ackerman, who I'm going to speak about in a few minutes, does, the right way to view this is to say that the Supreme Court between the early 1930s and the second half of the 1930s changed its mind about the New Deal legislation. This is not just transient majority legislation that is passed in response to a current emergency, but that when the people come to their senses, they will recognize as a violation of their deep-held constitutional principles. Their deep-held constitutional principles themselves have changed. They no longer view private property as so sanctimonious as a right that it should prevent the federal government from playing a more active role in protecting the economic security of the people, right? And so the difficult work of differentiating what the transient majority is doing in violation of constitutional principles as opposed to a change in constitutional views is integral to the argument that I'm making here. And the argument that I'm making is that the American people do, or at least the majority of them do, have deep held constitutional principles, and that the Supreme Court seems to be launching itself on a course that is in tension with many of those principles, and that the result will be that the Supreme Court's legitimacy, its standing, its authority will be increasingly questioned by many Americans, and that unfortunately this occurs at a very dangerous moment for American democracy, right? What we saw with the mob invading the Capitol, and it was just stunning to see that footage, to see just how chaotic and violent, anarchical that scene was. That's a one indication of the fact that more and more people seem willing to take force and law into their own hands, to mistrust elections, and in fact, to seek to overturn the results of those elections when they mistrust them. And this is one dimension of what has become a deeply polarized and rancorous period in American politics. It's a period where we really need a referee, where we really need some institution that says these are the rules of the game, and you have to abide by these rules. And that institution in our society tends to be the federal judiciary and the Supreme Court, and it can only do that work of serving as relatively neutral arbiters, referees, people that maintain the rule of law and the rules of political competition, if it maintains its respect from the people. And I worry that what's happening with the court growing increasingly out of step with the majority of Americans' views about the Constitution is that it is squandering that authority. And this is then the impetus for examining constitutional history, to review very briefly, right? I've tried to show you, I hope I have persuaded you that there is an imbalance in the Supreme Court, that in part due to luck, in part due to strategy, there has been a consistent Republican majority, a majority of Republican appointed justices to the court for the last 40 years. And that is despite the fact that there is clearly not a Republican majority in the American people as a whole. If anything, there's a slight Democratic edge, but obviously that's not mirrored in the court. This reflects the way in which justices have been appointed by presidents who have not won the popular vote, but nevertheless won the Electoral College vote, and been confirmed by a majority of senators who represent a minority of Americans. And this means that not only in terms of partisanship, but also in terms of ideology or jurisprudential views, the court is out of step with America. And we can trace this, right? That the way in which the Senate overrepresents rural, whiter, older, more conservative states, the way in which it underrepresents urban and suburban populations, the resulting ideological skew of the Senate, which is considerably further to the right than the average American, and the way in which that enables the Republican presidents to nominate far right judges and justices, whereas Democrats are forced to nominate moderates in order to get them passed. And the discrepancy, the racial discrepancy in the composition of the supporters, the constituents for our two major parties is, I think, ultimately underneath all of this. And I put Ezra Klein up here because, as you are aware, I'm strongly influenced by his views on these topics. And this diagram comes from his book, Why We're Polarized. I want also to return to the danger to American democracy. Most of these diagrams are diagrams I've shown you before. This one, it's been a while, but I will return to it now. And it shows, it's based on the research of Liliana Mason and co-authors, that there are four groups that a certain sector of the American electorate feels hostility to. Those groups are Blacks, Hispanics, Muslims, and gay people. And that people who in 2011 were quite hostile to those four groups, their willingness to support the Democratic Party has declined over that period. Right, that's that line. Their support for the Republican Party has stayed stable, or maybe even declined a little bit, but their support for Donald Trump and his wing of the Republican Party has gone up, right? And so it does appear that ethnic antagonism, hostility to those four groups in particular, is driving support for Trump's what's sometimes called hostile takeover of the Republican Party. As we've talked about many times before, the people who have high degrees of ethnic antagonism also seem to endorse the idea that it may be justified to use force to save their way of life, that they don't trust elections, that they're willing to take law into their own hands. Liliana Mason's more recent book, actually just published quite recently, shows, and I think this is quite distressing, that 60% of people she surveys say that members of the opposing party are a serious threat to the United States and its people, that 40% say that members of the opposing party are not just worse for politics, they are downright evil, and approaching 20% say that many members of the opposing party lack the traits to be considered fully human. They behave like animals, right? And I think two things to notice about this. Whereas the other diagrams focus primarily on ethnic antagonism in the Republican Party and the way in which it's eroding core norms like respect for elections and the rule of law and settling our political disputes through nonviolent means. This diagram looks not only at Republicans, but also at Democrats, and seems to reflect that the erosion of respect, to put it weakly, the growing hostility that seems to really demonize the other side is now bipartisan, right? And so this again indicates that not only have Republicans seemingly, at least a substantial portion of them, given up on the idea of the loyal opposition, that this is very dangerous for democracy, but that the degree of contentiousness in our politics is really dangerous in pulling us apart. I won't go through these quotes. That this is Bartels describing in his own language the danger this poses for democracy. I will very briefly reiterate that I think in a sense we are in a very dangerous moment for American democracy. There is democratic backsliding throughout the world. I think ultimately its causes are similar: disintegrative cultural change, dislocating economic change, rapid demographic change, disruptive technological change, right? In a sense, the ground on which we stand is shifting very quickly underneath our feet, and many people among us feel threatened, have seen their economic prospects diminish substantially, and are both scared and angry. When we get into the more specifically political factors, the rapid change in our media system with the rise of social media and digital technology is making it much more difficult to sort truth from lie, making it much easier for disinformation to circulate, and radicalizing public opinion, putting people in information bubbles in which the structure, the algorithm which organized the transmission of information, encourages, selects the most radical information for the widest circulation. the fact that we've lost unions, that our political parties have become much more rigidly professionally organized, and hence foreclose opportunities for popular participation. The fact that elites have captured, whether we're talking about interest groups or the hyper wealthy, democratic institutions so that they're non-responsive, and then the increasingly authoritarian drift of one of our two main political parties. All of this suggests that democracy is not healthy in the United States today, and we need all the help we can get. Obviously, we have to address the underlying problems, the economic change in particular, the rampant increase in inequality needs to be addressed in order to allow people the social security, the social standing from which to navigate these other changes. But while we are trying to address these problems, having the stabilizing, the buttressing institution of the judiciary to help us set the rules to bound our political competition is essential. And so that worries me deeply. In then thinking about the history and how we might gain some guidance for navigating our current circumstances, especially with regards to the Supreme Court and the Constitution, I want to turn to three works in particular. Michael Claremond's The Framers' Coup. Claremond teaches at Harvard Law School. This book is compendious. It's almost 800 pages long. It is, he claims, the first book that looks at the flaws with the Articles of Confederation, the Framers' Convention, the Constitutional Convention of 1787, the debates over the ratification of the Constitution, and the eventual adoption not only of the Constitution but of the Bill of Rights under the same cover. And there's a reason then it's practically 800 pages long. It tries to cover a tremendous amount of territory. And as the title conveys, Claremond suggests that the American Constitution ultimately is framed by a group of people who abused the mandate that they were given, right? They were not asked to write a new constitution. They were asked to change, revise the Articles of Confederation. The Articles of Confederation very clearly said, right, changes can be made to these articles only with the unanimous approval of all states. The framers said, if 9 states approve the Constitution, that'll be enough, right? And then we look at the actual work that the Constitution does. It redistributes power from the states to the federal government. And we know that one of the reasons the framers sought to do this and sought to create the specific structures of the federal government, the Senate, the Supreme Court, the federal judiciary, the Electoral College, was because they thought, in the words of Elbridge Gerry, that the chief vice that was affecting the United States in the 1780s was an excess of democracy. The Senate, the Electoral College, the Supreme Court were designed as institutions to cool democracy, to put in between the people and legislation a intermediary body of more reflective, even-tempered, statesman-like individuals. And so Claremont also gives us an account of the way in which the people at first reacted against and eventually decided to adopt the Constitution, but also demanded to make the Constitution a more democratic charter than perhaps what the framers had intended. The second book I want to draw on here is by Larry Kramer, who was for a long time at NYU Law School, where he was a dean and actually important in building NYU Law School to be one of the top law schools in the United States today. And he then moved to greener pastures, Stanford University, where he was also dean of the law school. And he is, I think, considered by most to be the most authoritative historian of the institution of judicial review in the United States, especially its institutionalization in the early 19th century. And his book, the only book that he wrote multiple articles, but only one book, The People Themselves, Popular Constitutionalism and Judicial Review, point out that at the time of the founding, the people considered themselves to be both the author of and the arbiters of the meaning of the Constitution, right? And that this is what he means by popular constitutionalism, and judicial review was difficult to reconcile with popular constitutionalism. And he's looking at that tense history of the contest between popular constitutionalism and judicial review. Finally, I think less eminent than the other two authors, but nevertheless, I think a really important, interesting book, Jason Frank, a political theorist at Cornell University. His first book, Constituent Moments in Acting the People in Post-Revolutionary America. And I'll start with the simple observation that the Constitution's preamble declares that it is enacted in the name of we, the people of the United States of America, who are seeking a more perfect union, right? And what Frank points out is, and you can see here his cover, which is a protest, a rally to call for universal male suffrage that occurred in Massachusetts in the aftermath of the adoption of the Constitution. And you might be able to make out by the dress that a lot of these people are not the aristocratic gentlemen gathered in Philadelphia, but ordinary farmers and workers. And by the way, there's an African-American man in the foreground as well, apparently protesting for the right to vote as well. The point is, right, that the people referred to by the Constitution and the framers and in Kramer's title is an indeterminate body. And in fact, part of the contest in the post-revolutionary period is precisely over whether the people who get to exercise popular sovereignty in drafting and ratifying a constitution are the propertied. Let us add, in case it's not obvious, propertied white men, right? Or do they include all white men? Or do they even include non-white men? And by the way, it's worthwhile noting that in the 1890s and early 19th century, there were states in the United States where women voted as well, right? That actually women lost the franchise in the middle of the 19th century before they regained it in the early 20th century via the 19th Amendment to the Constitution. And so obviously another question about the people is, does the people include women? And so Jason Frank's account here is of the very interesting, if you will, political grammar of disputes in which the people itself is contesting its own boundaries or constituents. Are you part of the people or not? Who gets to arbitrate that question? Without an answer to that question, it's very hard to determine who is exercising popular sovereignty. So before I go into the details here, I want to describe what I take to be four, well, really three propositions that come out of the late 18th, early 19th century debate around the American Constitution that remain relevant for us today as we think through the issue of what a democratic understanding of constitutional preservation and innovation mean. And so, right, how do we understand the Constitution not as the dead letter of a bunch of white slave owning men who, right, happen to be in the right place at the right time in our history to get to make a constitution, and the rest of us are just ruled by them, but as opposed to that, an institution that we, the people of the United States of America, here in 2022, get to continue to shape and influence. And so let's start with judicial review. And here, Larry Kramer's work is particularly important. And in a symposium on his book, another very eminent contemporary jurisprudential philosopher, Frank Michelman of Harvard, expressed what he takes out of Kramer's book to be the following: that the justices of the Supreme Court, if they are going to be compatible with the idea that the Constitution is the people's law, an exercise of popular sovereignty, have to be understood as the people's principles in protecting popular sovereignty and its expression in highest order law, in constitutional law, from transient majorities and vested interests, right? And so the justice's role is not as high priests of the Constitution to tell the um, uh, people who don't have the capacity to reason about the meaning of the Constitution, what the Constitution means, but instead to be our representatives institutionally in allowing us both to protect the Constitution when it is threatened, but also to extend the Constitution. And so the second big idea here, and this comes directly out of Larry Kramer's work, is that understanding constitutional interpretation and innovation as the essence of popular sovereignty and as being institutionally and politically dispersed should inform our understanding of judicial review, right? And I know I threw a lot in there, let me unpack it. The idea here is that the Constitution is deliberately written, expressed in language that requires interpretation in order to allow each subsequent generation to interpret the Constitution in ways that accord with their own understandings, their own principles, their own constitutional views, and that in particular, what we ask our representatives to do is to continue extending the meaning of the Constitution. And so to return to that New Deal case here for a moment, the Supreme Court in the 1930s had to decide, is Franklin Delano Roosevelt and the Democrats overstepping the bounds of what the settled view of the people is about its Constitution, or instead have the people change their mind about the meaning of the Constitution? And if FDR is elected once and then another president comes in, if after FDR's election, the usual swing of the pendulum to the other party occurs in the midterm elections, and then there's not stable support for his legislation, then there's no evidence that the people's understanding of what the Constitution permits has shifted. But if FDR is elected again and again and again, if the kind of legislation he supports ultimately becomes the kind of legislation supported not only by stable Democratic majorities, but also by Republicans, as did occur in the middle of the 20th century, then there's evidence that the people have innovated constitutionally in how they understand what the Constitution permits. And the Supreme Court, as the principles of the people, have to amend their view of the Constitution. And that's in part because, right, the Supreme Court does not have a monopoly on interpreting the Constitution. The other more political branches are also involved in the joint project of interpreting the Constitution. And the president, Congress, and the Supreme Court are ultimately accountable to the people as the sovereign in our constitutional democracy. This then gets us to the idea that I think is best expressed by Bruce Ackerman, but it's also there in Jason Frank's work, that in addition to ordinary legislation, typical disputes, transient majorities, vested interests trying to get legislation that suits their purposes and needs, we occasionally return to constitutional politics. We have what Ackerman and Frank agree in calling constitutive moments, in which the people resume the politics of making and extending or reinterpreting the Constitution, and with it change perhaps their own identity. The passing of the 19th Amendment makes it clear that women are full citizens. The passing of the 13th, 14th, and 15th Amendments makes it clear that there can be no racial exclusions for citizenship, right? And that these moments are moments when the people are doing something different. They're engaged in constitutional politics, not merely in ordinary legislation, and that the court and the judiciary and the other political branches of our government have to be sensitive to the fact that the people may revise the meaning of the Constitution. Finally, then seen in this light, the work that a Supreme Court justice has to do is difficult, delicate work. They have to use their judgment. They have to carefully try to differentiate when it is that the people is merely carried away by passion or fear or anger or some kind of extremism into doing things that it has agreed it should not and cannot legitimately do, and hence to be the brick, to be the institution that says this violates commitments that we have made to each other and has to be invalidated for the Constitution to stand, as opposed to moments where the people are actually engaged in constitutional politics and changing the meaning of the Constitution. And to be as clear as possible, I wish this were neat and easy, and we could just say, look, Roe v. Wade is so clearly the opinion of the majority of Americans and stably maintain that it absolutely meets the standards for being the expression of the popular majority in the interpretation of the Constitution. Rarely is it that neat and clean and easy. But having said that, it does seem to me that the prerequisite for the Supreme Court doing the work that we wanted to do within the theory of constitutional democracy that I'm suggesting was the reigning view in the late 18th and early 19th century, and should still be our view today, is that the justices at least acknowledge that they are the people's principles, that they have to interpret the Constitution based not on what it meant in 1787, but on what it means as an expression of popular sovereignty today. And I think part of the difficulty that we face in 2022 is that a majority on the Supreme Court entirely rejects that very understanding of their institutional role, and that we are likely to be in for trouble as a result. Okay, I'm going to stop there. I will go further into the history next week, and then bring us back into the 21st century at the end. But I want to leave a little bit of time for questions and thoughts. Who wants to start us out today?
I will.
Go ahead, Flossie.
So what I'm beginning to understand is that when there was an attempt to impeach the president, it couldn't move forward. It couldn't become clear that what we were facing was a coup. And one of the reasons we couldn't use the word coup is that possibly not only some of the Senate was involved with that coup, but possibly a Supreme Court justice.
Or his wife, I assume you mean.
His wife, there is that implication. So
Yeah.
you couldn't hold on to the word coup and actually go forward with the impeachment because too many supposedly patriotic people were involved in that coup.
Well, and so let's be clear, right? The impeachment failed, right? And it did move forward. In fact, President Trump was impeached, which means that the House of Representatives adopted articles of impeachment, but ultimately the Senate acquitted him. It seemed to be, in accounting for the votes, on somewhat technical grounds that they could not impeach him because he'd already lost the election and was not going to be the sitting president anymore, right? And so, having said all of that, clearly more and more evidence is being exposed. And while I'm not sure about the degree of complicity of particular senators with particular aspects of what is being described as a 6 or 7 stage coup plan, right? Which includes, for instance, getting fraudulent groups of electors to present themselves as alternative electors for the states that had already certified the official body of electors who would vote for Joe Biden in the Electoral College, right? Was there complicity on the part of any senators? Clearly, it was indicated, although I don't think we've seen the evidence yet, that there were members of Congress who asked to be pardoned by President Trump for their role in this. We'll have to see what specific evidence we have of that, and then to try to figure out what they thought their potential criminal liability was. Did it concern their efforts to bring those fraudulent groups of electors to muddy the waters and perhaps cause the disruption to the Electoral College that it appears then President Trump wanted? Or was it supporting the invasion of the Capitol, right? I mean, we don't know exactly what they did and what they sought pardon or immunity from. But having said all of that, I think the deeper issue here, Flossie, is not, was there a conflict of interest in this rather narrow sense? I'm not going to vote to impeach the president who I hope will pardon me for my role in his coup attempt, right? But the much more profound transformation of the Republican Party into a party that is in the grips of an autocratic leader, right? And you know, the fact that it appears increasingly that accepting the lie, the fabricated idea that the election was not freely, fairly, and clearly won by Joseph Biden as it clearly was, and as every court that has considered it has found to be the case, or increasingly it appears claiming that there's only one justifiable outcome to an election, not only the election of 2020, but the election of 2022 and 2024, and putting election officials in place that will seemingly try to produce that result. This is where we're really going to need the courts to do good work for us if this begins to happen, right? We have elected election officials refusing to certify the outcome of the election at the local or the county or the state level because it does not agree with their partisan views. That deeper corruption of the Republican Party, its drift away from a commitment to the rules of democracy, that should be what we're really disturbed by. And the way in which, right, the failure in various respects to oppose Trump, right? Liz Cheney's effort to appeal to the conscience of the Republican Party, I guess, is going to fall on deaf ears. I'm not sure that there's much of a democratic conscience left in much of the leadership of the Republican Party, as much as it pains and grieves me to say that. That seems to me to be the deeper issue here.
I agree.
Thank you, Flossie.
I do think that we need to educate even some of the Senate. They understand the meaning of the word coup.
Yeah. Well, I mean, and how do you educate somebody who's got their fingers in their ears every time you talk?
I know that's a hard thing to do, but we try. You're doing it now.
Liz Cheney is trying very hard.
Oh, she is tremendous.
Yeah, and I hate to say it, but what really is going to change the perspective of Republican elected officials is the moment they start paying an electoral penalty for their unwillingness to come to their senses, as far as I'm concerned, on these issues.
Thank you.
Yeah, thank you, Flossie. Anybody else with a question or a thought for today?
I noticed this is Karen Nelson.
Hi, Karen.
I noticed on TV, on the TV, there was a program this week on the January addition to the problem, the takeover of the White House. And I thought that was very significant. And they mentioned some of the issues you brought up, but I think that that's a good start.
Yeah, and so I'm wondering, perhaps you're talking about the hearings themselves.
Yes, the hearings.
Yeah. And so I do have to say I am encouraged if the ratings information I'm seeing is accurate, that 20 million people tuned into that means the audience for those hearings was larger than the audience for the World Series, and that despite the fact that the largest news network in the United States, Fox News, refused to broadcast it, right? Perhaps in a sense can't broadcast it given the content of what it regularly broadcasts and the direct contradiction, the effort to correct the disinformation. So all that to say, I hope, although I'm not very confident, to be honest with you, that perhaps this will be the start of producing, if not a shared narrative, at least a stably maintained narrative, one that reaches wider and wider audiences about the genuine danger to our government, to our system of constitutional democracy, that not just January 6th, but that the whole drift of one of our two main parties over the last 6 years represents.
Right.
Yeah. Thank
Well,
you.
I thought that they were going to do some other presentations in addition coming up.
Oh yeah, Monday morning. So just a couple days from now, will be the next hearing. I don't know if there will be other primetime hearings. My guess is that there'll probably be one or two more, but they're not going to try to do all of their hearings
Right.
in prime time because they don't want to exhaust or fatigue us.
Yes, I thought it was good.
Good, good. Anyone else? All right, then I'm going to say so long. And you guys keep being safe, taking care of yourselves, and I'll see you next Saturday. And at the end of the month, I think I'll be there in person to see you in person. Take care, everyone. Bye bye. Thanks.
Thank you, David.
Thank you, guys. Take care. Bye bye.